Good morning friends, 1404 video number. Yesterday it has come in Hindu that suspension of MLAs is worse than expulsion. Supreme Court held that. So a writ petition was filed. Before that, let us go to the details first. So the Maharashtra Legislative Assembly passed a resolution on 5/7/2021 to suspend 12 BJP MLAs for 1 year for alleged misbehavior as with the presiding officer. You may be knowing this speaker post is vacant in Maharashtra for so many years. Right? I think for 1 year. I should not say 4 minutes, for the past 1 year. So anyway, these 12 BJP MLAs, so they have misbehaved as per the Legislative Assembly resolution. They have misbehaved or they have behaved in a rude manner with the presiding officer. Of course, these things will happen. So they were suspended for 1 year. So Supreme Court held that this suspension is beyond the permissible limits. Same thing happened in Rajya Sabha also. 12 MLAs of Congress here, so counter Congress, they have been suspended and a lot of discussion is going on in that issue. So let us confine to 12 BJP MLAs of Maharashtra state. Right? So now the MLAs, Ashish Shekhar and others, so they have filed a writ petition number 797/2021, and Supreme Court had to interfere on 11th January 2022, and they have given interim orders. So you can see the cases Ashish Shekhar and others versus the Maharashtra Legislative Assembly and another. Right? In this case, Justice A.M. Khanvilkar and Dinesh Maheshwari, they observed that suspension for 1 year is worse than expulsion. Why? Now the important point. So please refer to Article 190, Clause 4 of the Constitution of India. You may be knowing. If the Article 190, Clause 4 says that if for a continuous period of 60 days, without the permission of the Speaker of the Assembly, if an MLA is absent, the House may declare the seat vacant. So 60 days absent from the Assembly, continuous absence should not be there. Right? So of course, if the Speaker permits, no problem. That is, the Legislative Assembly permits, no problem. Right? So Article 190 Clause 4 says, if it is vacant for 60 days, definitely the Speaker can declare it as vacant, and definitely not one MLA. 12 MLAs, maybe MLA or MLA, for them all of them. So what is the position of MLA? He has to represent the grievances of his constituency people, or he has to solve the grievances of people, and he has to enter the assembly, he has to raise his voice regarding the for the redressal of the grievances of his constituency people, is it not? He is there to represent in the assembly. What is the use of suspending him for 1 year? 1 year, if he cannot enter the assembly, how can he solve the issues of the general public? Right? So please remember, statutory obligation is to fill the post within 6 months also. Of course, you may be knowing, suppose if any person can become a minister or PM also, of course, if he is elected within 6 months, then only his post will be there. Otherwise, definitely it will be held as vacant. So with this suspension of the MLAs for 1 year, what is happening? The Supreme Court observed that a constitutional void is happening, and a hiatus, HIOTY situation is arising. So you cannot create such a constitutional void. Right? Of course, here Advocate Tamil Nadu famous R.M. Sundaram, he stated that the court cannot examine the validity or the quantum of punishment imposed by the Legislative Assembly. Immediately the other party said, yes, there is a judicial review. Definitely High Court or Supreme Court can go for judicial review on the issues like this. So please remember, even the bench also did not agree. So of course, then the Aryan Sundaram advocate, he said he will take instructions from the state of Maharashtra and then respond. Anyway, the matter is posted to next month 18th. Here the main problem, why I have made these videos, please understand that the suspension may be there, maybe 2 weeks, 3 weeks, or at least 2 months. But if the suspension is continued for 1 year, then actually the constitutional void is being created. Such a situation should not there. Whether he is good or bad, whether he is a bad fellow, MLA, we are not bothered. But he is a people's representative. He has to represent the grievances or the problems of the people, where in assembly, is it not? Assembly is the forum. So if he is not allowed for 1 year, what will happen? This is the right intervention taken by the Supreme Court. Definitely they have to come back, or the Maharashtra legislature definitely they will call back, and things will be normal. Very good judgment, particularly as regards the intervention petition. Why Supreme Court has to intervene? Because to do the justice, if it is anything against Constitution, definitely Supreme Court will interfere, and this is one such example. So please remember this case as Ashish Shekhar and others versus Maharashtra Legislative Assembly and another in WP number 797 by 2021, of course, which was posted on 11 and posted to 18 February next month. Thank you very much.